Hello, and in this video I want to have a look at how can the innocent party respond to an anticipatory breach. So sometimes you'll hear critics of the law say that the law surrounding anticipatory breach is very much favoured towards the innocent party. Now this is because when an anticipatory breach happens, which is where one party displays and communicates the intention to breach the contract in advance of the contract, does so, then the innocent party has the power and the options to decide A, how they're going to respond, and B, what will the repercussions and the consequences be of this breach, because they are choosing how to respond. So they have two options. They can either accept the breach or they can affirm the contract. Now, if they choose to accept the breach, then they can immediately get damages, and that's that. But what's more interesting is what happens should they choose to affirm the contract instead. Now, just a slight caveat to what I was saying about the power that the innocent party has. They might have the power, but they also are very limited. Like, they have to stick to the option they make. They cannot choose to affirm the contract and then try to get the damages from what would have happened should they accepted the breach. So they have to stick to their guns wherever they go, but they do have the power to choose. So we've already talked about that they have the option to accept the breach, claim damages. What happens should they choose to affirm the contract? Now, assuming that if they're going to assume the contract, they fulfill the obligations as required by the contract, all fine. Then what would happen is at the end of the contract, so you'll see my video about White and Carter, at the end of the 3 years of fulfilling the contract of advertising or whatever it was in that case, then you can claim the full contract price. So you can claim a bit more than damages. But remember, you can only do this if you fulfill the contract yourself. Because when you're affirming contract, you run the risk yourself of not being able to fulfill your own obligations, and therefore you yourself will be in breach. So, for example, you'll see my video of the Simona 1989 case that there was an anticipatory breach from charterers of a ship, and so the ship owners, they decided to affirm the contract and then went to sue them for the full contractual price. But this was not an option because they themselves, as a ship owner, they could not match their obligations. They could not have the ship ready in time for the hirers, so they were not able to get that full contractual price. So I hope this helps, and see my blog. Thank you.